a full room, so thank you all for taking the time and being here with us. We are now having our distinguished lecture, one of the many of the ASEE series, but in case you don't know which one you're attending, this is the distinguished lecture on open access and open educational resources, the Internet's growing role in scientific communication and education. This lecture is sponsored by the Engineering Libraries Division, and the Engineering Libraries Division in turn would like to acknowledge the support of ProQuest for offering this lecture this year at the conference. It gives me great pleasure to introduce our distinguished speaker this morning, Professor Michael Carroll. He's Professor of Law and Director of the Program on Information Justice and Intellectual Property at American University, Washington College of Law. Michael Carroll's research and teaching specialties are intellectual property, law and cyber law, focusing on the search for balance in the face of challenges posed by new technologies. He is a founding member of Creative Commons, a global organization that provides standardized legal and technical tools that enable legal sharing of cultural, educational, scientific, and other copyrighted works. Professor Carroll is also recognized as a leading advocate for open access over the internet to the research that appears in scholarly and scientific journals. He has written white papers and has given numerous presentations to university faculty, administrators, and staff around the country on this issue. In addition, he serves on the National Research Council's Board on Research, Data, and Information, is an academic fellow of the Center for Democracy and Technology, is a member of the Advisory Board to Public Knowledge, and recently he joined the board of the Public Library of Science. Prior to entering law teaching, Professor Carroll practiced law at Whitmer, Cutler, and Pickering in Washington, D.C., and served as a law clerk to Judge Judith W. Rogers, U.S. Court of Appeals for the D.C. Circuit, and to Judge Joyce Hans Green, U.S. District Court for the District of Columbia. He received his AED in Anthropology with General Honors from the University of Chicago, and his JD Magna Cum Laude from the Georgetown University Law Center. So once again, thank you all for attending, and I'm going to turn the podium to Professor Michael Carroll.
Thank you, Adriana. Thank you to the Engineering Libraries Division and the Graduate Student Division for their sponsorship and invitation, and thanks to ProQuest for this material sponsorship. It's a treat to be with you today, you heard that I'm associated with a variety of nonprofits. I'm here to speak on my own behalf. I'm not speaking on behalf of any of those organizations. You know, as lawyers, we've got to get our caveats out there. And I'm a lawyer, and a lot of people experience lawyers as people who say no. And I'm a different kind of lawyer, so I have a very sort of strong sense of empathy with engineering, because I think of law as a kind of human engineering discipline, right? That we create rules and systems that create incentives and create flows of human activity. And rules are there to constrain some kinds of activity and encourage others, much in the way that you might want to increase the resistance or promote the flow of electrons through a system. And what I want to talk about is kind of our information system and the changes that the internet brings to our information environment. And I'm a copyright lawyer, and copyright is one of those regulations that creates the sort of boundary conditions for the flows of information. And those rules were based on a print world. And I would argue that we are very early days still in our adaptation to the digital environment, both the digitization of the information, but also more importantly, the fact that we're operating in a networked environment. And so you talk about, you know, the session that we just came from, the Libraries Division talking about consortia, right? There's a lot of ability to share cost and share research, share resources in a networked environment. But from a social and institutional perspective, it's more difficult. Well, what percentage should my institution pay for this common resource? So the governance issues around the network environment are still one of the things that need to be worked out. And as a lawyer who does human engineering, I think that's one of the places where I might be able to contribute. The other thing is we've just got a long set of publication practices, publication expectations in both the scholarship and the educational spheres that are very slowly adapting. Again, we're in really early days. And the way I think about this phase change, or whatever, however you want to describe it, it is somewhat analogous to some of the behavioral change we've seen with respect to the physical environment. So let's think about recycling behavior for a minute. So there's enough of us in this room of a certain age that if I were to dial the clock back, let's go 30 years or so, and let's think about what recycling practice was then. You just put your cans and your newspapers out on the curb, right? No. Saturday morning, you tied up your newspapers, you bagged your cans, and you burned some fossil fuels to go to the recycling center, where you dropped them off, and you felt like a virtuous citizen, right? Why? Because there was a vision inspiring this behavior that said, responsible stewardship, responsible behavior means not just putting this stuff in the landfill. It means putting these resources to more productive use. We can do better, and we should. That was all being done by individuals operating at the individual level based on their own vision. Now, if you think about our behavior today, how many of you routinely recycle your newspapers and cans? Okay, big change in behavior. What happened? Well, that vision became adopted by institutions and governments. It became supported at the institutional and governmental layer, making it easier to comply, easier to engage in that behavior at the individual level. And with respect to open access and the publication of open educational resources, I would argue we're in the same kind of transition. That certain educators, certain scholars were early on to say, here's this internet thingy, what are we going to do with it? Oh, let's share our research, let's share our educational materials on it. And they engaged in individual behaviors, maybe changing the publisher's publication agreement to say, hey, I've got the rights to put this up online. Or, I just wrote this book, or these course materials, why not let everybody see them? Right. And we are now in the institutional transition phase, where institutions are getting in on the act. And what I'm going to talk about a little bit is this transition in both scholarly publishing and educational publishing, where we're moving from the individual visionaries to the institutionalization of open publication practices. All right, so here's our work today. We're going to talk about these 4 things. Yeah. Oh, you can't hear it? Ooh. All right. Usually I speak pretty loud. Okay. Stadium style. I'm kidding. All right. Okay, so here's our agenda. I'm going to do this modularly. We've got 4 modules. I'm going to break after each module for any Q&A because each module builds on the prior one, and I prefer a more interactive style. And actually, if you want to interrupt me to just get something I say on point, that's fine with me. We don't have a room mic at the moment, so if you ask a question, as long as I can hear you, I'll repeat it so the rest of the room can, and we'll move along accordingly. All right, so last day of the conference, windowless conference room, but we ready to work? All right, here we go. All right, so the title talks about openness, so open must be opposed to closed, and let's talk about what open and closed mean with respect to sort of the regulation of information resources. So I'll just do 500 years in 5 minutes, if that's okay. So if you think about it, the book publishing business has actually been around since about the 5th century BC. That is, trade in manuscripts has been traced. You know, once we had paper, we had the book trade. And you actually had manuscripts being sold at book fairs and the things, you know, continuously, even during those dark ages. And at that time, if I got a copy of a handwritten manuscript as a sort of interlibrary loan, the behavior that would be most socially productive would be to make a copy of it. These were scarce resources, expensive resources, and you didn't want to lose the information encoded in it. And the best way to preserve it and make it more widely acceptable was to copy it. Right? But that changes when the printing press comes along, because now we have a technology that makes those copies easier to make, But as a result, it also creates a risk. Right? Now, I'm going to take this olive press, turn it into a printing press, and take a chance on spending money on expensive paper to publish something that I hope the buying public will pay for. And the risk is that some rival will be smart and wait for me to go first and take the chance. And when the rival sees which titles the buying public will pay for, then the rival enters the market and undercuts my price because they didn't have to take the risk of having some losers. And so the basic idea of copyright is born with the printing press. It is, how do you manage that risk? How do you keep that rival publisher from waiting for the successful titles to emerge and just copying those? And so what the publishers did is they petitioned the legal authorities, the Venetian Senate, the English Crown, the French Crown, for some kind of legal protection that would basically say, give me the right to sue that rival publisher if they copy my titles, give me the exclusive right to publish. And so we had these things called printing privileges that were issued to printers, and they had the features of copyright in the sense that they gave a publisher the exclusive right to publish a particular book for a period of years within a particular territory. And the term copyright actually emerges from the English situation, in which these rights were given not just to an individual printer, but to the guild members, the stationers' company, which were sort of three different guilds that had collectively the exclusive right to publish books in the city of London. They couldn't publish a book until the king's licensor had gone through censorship review, and part of copyright's job was to bolster the censorship review. So booksellers had an interest in suing anyone who was publishing uncensored material. And the term copyright emerges as the way that the guild members regulated their behavior amongst themselves. Once you got a hold of a manuscript, you went to Stationers' Hall, which still stands in London today. You can go there today. And you'd go to the register, which was this big fat book, and you'd enter your name and the name of the title. And by doing so, you claimed vis-a-vis your other publishers, hey, this one's mine. And in fact, if one of your other publishers inside the guild published that title, as they sometimes did, the guild had its own little court system, and they had their own little arbitration system where the publishers could sue each other and for violation of that copyright. What shifted is that sort of monopoly publishing practice dissolved at the end of the 17th century as a general political hostility to monopolies grew in England. The Crown was financing itself by giving out monopolies on staple crop things like salt and the other things, and people were saying, wait a minute, this isn't right. So the publishers went back to Parliament and said, please, 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 we're different, we need our monopoly back. And Parliament was unpersuaded, so they shifted tactics and said, well, it's not about us, it's about the poor author and their families. And Alexander Pope and a few other sort of stepped forward and said, yeah, it's about authors. So copyright shifts from a publisher's right to an author's right with the first Copyright Act in 1710, the Statute of Anne. And that system, the sort of rule set that you got with the Statute of Anne, the basic features have stayed in copyright law. That is, it's an author's right, it lasts for a limited period of time, and it has certain limits on the rights, but it also has a certain sort of scope of exclusivity that the right owner owns, and the author can transfer those rights to a publisher. Right? But for the longest period, you had to opt into this system. Right? The author or the publisher had to do something to say, I want copyright. And if they published without doing that, they were telling the world, I don't want copyright, you're free to copy. And we found that that was actually the system that the US, the founders of the United States accepted. So the Constitution gives to Congress the power to create a copyright law. And Congress did so in 1790, and we've had copyright in the United States and throughout most of Western Europe, certainly since the 18th or early 19th century. Now, one of the things that change, when you think about intellectual property, there's sort of three different things to think about. What is the information that counts as intellectual property? Whether we're talking about patents, copyrights, trade secrets, trademarks. What does it take to qualify? So this recent patent decision by the Supreme Court on human genes, IP lawyers would take that as a subject matter question. The question was, is a purified version of a naturally occurring gene the subject matter of patent law? And the court sort of split the baby and said, if it's just the naturally occurring sequence, no. If it's the cDNA, yes. So that's sort of the nouns. What's the it that the rights attach to? The rights are the verbs in the system, right? These are the activities that trigger the ability to enforce. What are the exclusive verbs owned by the right owner, and for how long? An important thing to understand about what happens to copyright law that now affects us in the internet era is that originally the nouns were things. It was exclusive right to trade in printed artifacts, and the rights were attached to the idea of the printed artifact. So originally copyright only applied to books or maps, charts, and books. Right? So visual art is not there. If I copied your painting, you didn't have a right to sue me because visual art was not on the list. And for a long time, copyright law had a list. And if your subject matter didn't fall within the list, it was unprotected. But we kept getting new technological developments. Well, what's a photograph? After we protected paintings, is a photograph a painting? Well, it was produced by a machine, so it's not really a work of authorship, but it's creative, so let's protect photos. Well, now we've got moving pictures, right? What do we do with moving pictures? So what the early movie makers did to opt in the copyright is they actually created paper prints of the whole sequence of the moving pictures, and they would register that sequence as the copyrighted sequence of photographs. That actually is important for the preservationists in the room, because all the silver nitrate that burned up a lot of the film meant that those early films are gone, but these paper prints are still existent, and you can digitize those and turn them into a video. So we've actually got really early films that we can preserve, and then we've lost sort of a period. But that was all about sort of the things. In 1976, Congress shifts the idea. Copyright is now an original work of authorship. All it takes is a minimal spark of creativity and some creative decisions that you have to make, and then some ability to fix those creative decisions in some kind of medium of expression. If you do those things, you've got a copyright. And what this does is it's a shift from the exclusive list based on physical objects to a more abstract layer of copyright. So now any kind of creativity qualifies for copyright protection, which means copyright gets its fingers into areas that people would not have expected. Again, I know I don't know whether you consider synthetic biology an engineering discipline or not, but is a person who creates a synthetic biological sequence an author? Well, maybe, right? How different is it from software? And so we might start to see copyright claims on genetic sequences of synthetic biological organisms. Why is that possible? How could that make sense? Well, it's this layer of abstraction. So copyright reads on it, attaches itself to unexpected places. Right? And it lasts for a long time. It used to be two 14-year terms. You had to opt into the second term, or else it went into the public domain. And a terminology point, when I say public domain, I don't mean it's out there in the public or published. I mean it is free from copyright. Right? To be in the public domain for a copyright lawyer means there is no copyright attached to it. Okay, scope. You now get a series of rights. In the era of things, what copyright controlled was the reprinting and the selling of copies. So if I bought a sheet of your sheet music and I took it to the tavern and I played your music and got paid for it, you would have no complaint because I wasn't publishing sheet music. That's what copyright was about. The fact that I was making money off your music didn't matter because we didn't conceive of copyright as being a way to claim any kind of money that's made off of the work. Once we get more abstract and the rights attached to the work in its abstract form, Then we start claiming the verbs increase. So now the public performance of the copyrighted work is an exclusive right of the copyright owner. The public display, the right to adapt. Right? What's the shower thing there? Right? Well, copyright's automatic now. So as you take notes, for the few of you who are, you are taking my words, making your original expression from my words, and the federal law is showering down upon you these exclusive rights. You are getting copyright, you're getting drenched in copyright. And because of our international agreements, you're not just getting one copyright, you're getting about 190, right? Because copyright is territorial. And that means every country has its own copyright law, but by international agreement, most of the members of the world, well, the members of the World Trade Organization and others have agreed to automatically extend copyright in their territories in exchange for us doing so here. So you're getting a French copyright, you're getting an Australian copyright, your work is protected wherever it goes out in the world. And that's the vision, right, of copyright, is we need to protect the investment in the information wherever it may go. Now, the scope is limited by limitations and exceptions. So fair use, you've heard the term probably, means that even though the author owns exclusive rights in the work of authorship, if what you're doing with it, your verb, counts as a fair use, then there's no problem, right? The exclusive rights do not prohibit you from making fair uses. First sale is a disappearing user right, but that was the used bookstore. When you buy a used book, the author doesn't make any money because the right to distribute the work was exhausted when the first sale took place, and further reselling of that copy is not something the copyright owner has anything to say about. In the digital environment, though, if you go back to those rights, right, in the digital environment, you're always making a new copy. And the first sale limitation only applies to the distributing of an existing copy. So if you have to make a new copy, then the copyright owner can prohibit that. There's a website called Redigi that was trying to allow you to resell your used iTunes files and your music files and basically create the used record store experience. But because of the way the law has been written, a federal court prohibited them from doing that, even though they had a system where it would be deleted off your server or your disk in order to be on someone else's so that it would functionally be the same. The law is technical in this respect. So fair use has a lot of work to do, and we'll talk about fair use briefly in a minute. The other big change is throughout the opt-in point remains. So you used to have to publish with Circle C, and if you didn't publish with Circle C, you were telling the world this is free for you to use. That changes, and by March 1st, 1989 in the United States and previously throughout the rest of the world, copyright was automatic. There were no formalities, no Circle C required to get and to keep your copyright. So now we have this automatic set of rules that attaches. It's hard to get rid of, and there's no formalities. You don't have to tell anyone where you are, who you are as the copyright owner. Right. Now, going to our theme of open and closed, from the author and publisher's perspective, these exclusive rights give them property in the information, and you need to come ask them for the rights to use their property. And these properties can and have been sold and transferred. So here's an example, and I'm not picking on the IEEE. This is a typical publisher agreement, right? If I want to publish your material under the traditional basis, you need to give me the copyright in that article, and I will then give back to you a license. This is actually not worded correctly because it says without permission, you can host it without permission, but they're saying it's my copyright now and I hereby give you permission to put it up on your own personal website. So it's not without permission, it is with permission. But notice the shift. In the first paragraph, it's your copyright. By the time you get to the second paragraph, it's already IEEE's copyright, right? And that is the traditional way in which scholarly publishing has operated. And the reason is because we were in a print-based world in which IEEE or any other publisher was going to invest resources in creating and distributing expensive printed artifacts, right? And in a world of that kind of investment, wanting to have copyright to protect that investment was a reasonable, rational way to run your business. But now, how many of you, so another example, 1990s, let's say 1995. All right, authors in the room, I'm going to give you a choice. You can't have it both ways. You can either publish in a print-only journal or an online-only journal. You have to choose. We're in 1995, what are you going to choose? How many would choose print? How many would have chosen online? One, right? That's right. We all were there, right? Online, who knows? That website could be gone tomorrow, right? Print lasts, right? Okay, let's run the question now. How many of you would publish in a print-only journal? You would. We got one. How many of you would publish online only? Right? Right? Why? Because we've come to learn that this online environment is a more stable environment than we thought of, that lots of copies keep stuff safe, that there are different ways to handle the preservation aspect and the access aspect that online is so much more important. And the librarians in the audience will already tell you that they're off-citing those physical journals, right? The circulation numbers have plummeted. It's the online access, the online environment in which we are. And so what it means to be a journal publisher now is to be a database manager, right? It is not to print and distribute printed artifacts. But we still have a set of copyright rules and practices that are based on the printed artifact model rather than the electronic network database model. And that's where I would argue we're in a phase change. Right. This is just, my slides are all CC BY for all of my content. I've got some screenshots and other copyrighted works that are fair use. Speaking of fair use, I'm not going to do a little tutorial on fair use, although happy to answer questions, but for the leave behind, here's the quick little, what is fair use? Well, it's a little balancing test. You ask a set of questions. Remember, the questions should all be based on what's copyright's job. Copyright's job is there to maintain the economic incentive to create and distribute works of authorship. So if the use you want to make is the kind of use that would threaten the author or publisher's economic incentives to produce that, then the chances are that's not a fair use. If, on the other hand, your use is unlikely to have any impact on the economic interests of the author or the publisher, then its likelihood is that it may well be fair. So I don't think the owners of the copyrights and the websites that I'm going to show you are in any way harmed by my having copied them and thrown them in this deck, because they're not making money off that copyright work anyway. But formally, the legal sort of question set is, why are you doing this, right? And the magic word in the law now is it transformative? And you have to put that in quotes, because it doesn't just mean are you transforming the work of authorship, but am I doing it for a different purpose? So when Google creates little thumbnails of photos in its image search database, it is just copying the copyrighted work, but it's doing it for the purpose of creating a search engine, not for distributing copies of the photo. And the court said that's a transformative use, even though it's an exact duplication. So transformative is the magic word that means this is very likely to be a fair use. We also want to know, are you making money off this or not? How much of the author's expression is involved? Is this a factual database with a little bit of expression in the selection and arrangement of the data? Or is this, you know, a Harry Potter? How much are you taking, and this is both a quantitative and a qualitative question, are you taking the economic heart of the work? When the Nation newspaper snuck in and got an advanced copy of Gerald Ford's memoirs, they republished 300 words about why he pardoned Nixon out of this long book, and the Supreme Court held that was not a fair use because they had taken the piece that everyone was going to buy the book for. And so, ironically, the same thing happened when Hillary Clinton published her memoir, and the Associated Press somehow got a hold of the section of the book dealing with the Monica Lewinsky scandal, and they republished that, and it was like a rerun of the same case. And then finally, if you were making this use, what does it do to the economics of the copyright owner? And here we want to say, are you affecting their sales or their licensing opportunities? And you have to not just look at, well, it's okay, I'm not hurting anybody, but you have to say, well, if it's okay for you, it's okay for everyone else. So in the aggregate, if everyone can do what you're doing, is that going to harm the copyright owner's rights? So I realize this doesn't give you clear and easy answers to every particular use question you might have, but it also doesn't mean that it's a useless way to figure out what's a fair use. Lots of industrial players rely on fair use every day. Saturday Night Live, Jon Stewart, they're throwing copyrighted images up, they're playing copyrighted works as part of parodies and satires without asking permission, because there's a pretty clear set of court rulings that say that kind of use is what we mean by fair use. Reverse engineering of software to get at the basic operating procedures that are embedded in there, that's a well-established fair use. So fair use has more clear guidelines. In the educational space, the Georgia State case on e-reserves is on appeal, and we're waiting for a little guidance there. Certainly some level of putting copyrighted works up in e-reserves is a fair use, and we're really just trying to figure out how much. Okay, here comes this internet thing, right? So we've got this automatic world of automatic works of authorship protected, exclusive rights that attach automatically, subject to fair use. And now we've got this technology that lets us easily copy and transmit and distribute copyrighted works. So now the technological capacity of end users has increased significantly, but the legal regulation of their behaviors has not changed. The legal regulation is still based on a model of commercial rivals trying to eat each other's profits. And so we have a mismatch between the distribution system that we now all participate in and the one the rules were designed for. And we know that one size does not fit all. We know that these rules are optimized for the commercial producers and distributors, and a lot of the non-commercial use of copyrighted works are not well suited for the regulations. And I sort of think of this as an eruption or an explosion of what I call copyright events. That is, the things that cause copyrights to come into existence, and then the uses of those works that copyright would purport to regulate. So all of those sharing and posting of, and reblogging and all of those activities are the kinds of activities that fall within the scope of copyright. Okay, end of module 1. That's copyright in a nutshell. There's more I could say, but I'm trying to keep it brief. Are there, anybody got any? In the back.
No, I just have a mic.
Oh, we have a mic, all right. All right, our attention span tends to be about 20 minutes, so, okay, mental. Oh, we got a question, all right.
So if you're writing something...
Oh, the mic's coming your way, we actually...
So if you're writing something in a blog, a technical thing or whatever, and you're saying that that is, by its own very nature, it's already copyrighted?
Yes.
You don't have to put down copyright on the bottom? So,
that's right.
But what kind of implications does it have in controlling? Is there, if somebody uses it in order to preserve that copyright, do you have to actively try to go after those people, or does it continue to persist?
Right, so traditionally the enforcement of copyright has been up to the copyright owner. So it's up to you to decide whether you want to chase after them or not. And if you let it go for a long enough period of time, you'll lose your ability. But that period of time would be like 8-10 years or something, where you know about it and you chose not to sue them. At some point, we're not going to let you, come to rely on your non-enforcement and then you surprise them years later. But that's a rare case. Otherwise, you have a right to sue anyone who is using your copyright in a way that you have not given permission for, right? Does that answer your question?
Yeah, kind of.
But it's up to you. I mean, it's not like you can go to some government agency and say, hey, they're misusing my copyright, go punish them. It's up to you to decide whether to bring the action or not. Question over here.
Particularly in the field of engineering, there are lots of presentations that describe and portray the derivation of equations or formulae or other standard things that a lot of people do. And so when someone creates a manifestation of one of these presentations, that becomes copyrighted, but the material in and of itself is public domain, I should think. Can you comment on that?
Sure. No, that's a nice point that should be brought out. So copyright attaches to the author's original expression of facts and ideas, but the facts and the ideas themselves are in the public domain. So if I'm understanding you correctly, sort of a set of mathematical relations is not something that you can claim ownership over. That's an idea. That would function as an idea in copyright land. If you chose to, make it as part of a painting or something like that, portray it. So you might get a thin little copyright in the creative way in which you choose to manifest it or express it. But I can extract from that the underlying idea without using your copyright. And we would also treat mathematical formulae that express real-world relationships as facts that are not authored. And so in the scientific disciplines, a lot of data are not subject to copyright because they're trying to represent the factual world. Copyright might attach to the originality in which you create a figure or to decide what the Excel spreadsheet headings are. If you have multiple choices, if you don't have choices, if there's a standard way of doing it, then even if you had a copyright in the first place, if everybody has to do it that way because of the way the discipline works, then the idea and the expression merge and there's no copyright there. So there might be little copyrights attached in those situations, but to the extent that there are little copyrights, that's where fair use probably, I don't want to opine on it, but in general, fair use has a lot of scope in that kind of sort of information exchange.
Just as a follow-up to the gentleman's question is, I perceive, and I think most of us and students perceive, that anything that is on the internet is free and public. So when you say that blog is also copyrighted, shouldn't we clarify or put a little, no, this is copyright, or contact the author, or contact copyright? You go to CNN, it says share. So most people have accustomed already to the fact that if it's in there, it's free.
Right, so this is a nice point. And I think there is some, so we'll talk a little bit more about transferring and licensing copyrights. But when somebody, so a non-exclusive license, which is the same as a permission, can be granted very casually. So if I publish something on the open web in a blog, I'm certainly telling you that you have the right to make a copy of it in your RAM to look at it, right? I must know that that's what you're going to do. So I'm probably giving you what we would say is an implied license to do some things with that. Certainly to read it, probably to make a copy of it for your own use. But do you have the right to republish it? That's where the scope is. So even if it's under copyright, it doesn't mean there's no use that's permitted. It just means it's not completely free for any use. Okay, let's talk. So I'm on board of this Creative Commons thing. I'm not speaking on behalf of Creative Commons, but I do want to explain it because this is one of the sort of human engineering responses to the mismatch between copyright and the internet. So what Creative Commons tries to do is create the clarity that you're asking for. If your intention, when you put things online, is to share, is to tell people you all have permission to make the following reuses, Creative Commons provides a set of standardized copyright licenses that allow you to communicate that to the public so that they have some clarity. And the goal of these licenses is to go beyond fair use. So the license doesn't kick in until what you want to do is something that fair use would not permit. So there are 6 licenses, so let me just go past. So basically the idea was, let's assume that there are a set of authors out there who want to make their materials free for reuse, but they want to hold on to at least some of the control that copyright gives. So they want to put some conditions on reuse. What conditions might those be? So attribution, at least give me credit. If you took it off my blog, at a minimum, give me credit. We used to make that an option. Our data was showing that 98% of people using our licenses wanted credit, so we just baked that in as an automatic. So you have to give credit, and the credit has to be given as the licensor directs. So in the case of open access, it might be author is X, Y, and Z, original publisher is blank, right? So that gives me the right to republish, but I have to tell you where it originally came from as part of my attribution obligation. Share alike, it comes out of the sort of open source, the viral licensing of open source software. It says, if you create a derivative work based on my work, and my work is under this license, you have to license your derivative work the same way. So it's a way of sort of forcing the openness downstream. Non-commercial means you're free to do anything you want as long as I get credit and what you're doing is non-commercial. If you want to make a commercial use, come and talk to me. And the last is no derivatives. I'm fine with you republishing it as is, but I'm not okay with you translating it or adapting it, putting it in chunking pieces of it out. It's got to be full republication or recopying. So those 4 conditions combine, the permutations run to these 6 different licenses. So, and these are the little icons by which we try to make it easy for you to see which rights as a user the copyright owner is giving you. In addition, if you want to get rid of the copyright altogether, and in the scientific data space, we are seeing that this CC0, the one on your right, is there to say, you know, most of this database is facts, and maybe I made some original decisions in how I laid it out, but I don't want the copyright concerns to get in the way of the reuse of this data. So I'm going to strip that little layer of copyright off, and now the whole thing's public domain, go for it, right? The other one, the public domain mark, is just a label. It's not it doesn't do anything legally. All you're saying is, this thing is already out of copyright, and therefore I'm just letting you know that this is in the public domain. And you get sort of layers of control that you can use within this license suite. In addition, we try to layer the expression of these permissions at 3 layers, sort of the lawyer readable layer, the human readable layer, and the machine readable layer. Right? So the human readable D, this is just a sort of quick and dirty one-pager that says, the person who gave you this material put it under a Creative Commons license, and you are free to make the following uses, which is up on top, subject to these conditions. So these are the basic terms. If you don't want to read all the fine print, at least you know what the basic rules of the road are, and there's a link to the full legal code. If you're an institution or you're worried about the fine print, by all means you should read it, and there it is. And it looks like that. So what's been the uptake? Well, this is data, I mean, I don't have a nice graphic that's up to date, so this is like 2010 data. We can't measure the actual number of objects to which this license is associated. What we can measure are the link backs to the license page. So we've got, at this point, 500 million plus link backs, but there could be multiple copyrighted works associated with one link, or the link could only be a piece of a page. So it's noisy data, but it's the best that we've got. We launched with MIT OpenCourseWare. We weren't going to launch with no adopters. MIT was one of the early adopters, so all of the OpenCourseWare, if you're aware of those materials, are under a Creative Commons license. So interestingly, that reuse, a lot of people are worried about, should I allow the reuse? and especially in the case of unauthorized translations into other languages. On the one hand, I want my information to become accessible. On the other hand, I'd like to be able to authorize the translation. The way MIT handles that concern is they have authorized partnerships with authorized translators, but they recognize that the CC license allows for unauthorized translations as well. And they permit that, but they use the attribution condition to say, you just have to let the world know that we didn't endorse your translation, that you're making use of the right to translate under the CC license, but this is not an MIT approved translation. And as long as you mark it that way, we're fine with it. And one of the early success stories of this is MIT put all these courses out there, and a number of Vietnamese universities, without asking, translated a number of these courses into Vietnamese and started teaching from them. And the folks at MIT were delighted, right? This was the point, to make the educational materials more widely available. The other early adopter, and this is my shout out to the engineering community, because it really was the engineers at MIT and Rice that were the forward-looking group at Rice Connections. Also adopted the CC license for these learning modules. And computer science, music, and a few other disciplines were the leading disciplines, but we've gotten an increasing number of modules that are all available. In the science publishing area, the Public Library of Science was an early adopter that said we can change the funding model for scientific publication, and we can use this Creative Commons license. So we will not take money from the reader side. We'll make all the content available for free on the internet on publication. We will finance the publication process through article processing charges, and we will make the content available under the most open CC license. So all you have to do is give us credit, you can translate it, you can do anything else you want with it. That use of the CC license has now increased. There's now a trade association of open access publishers. To be a part of the trade association, you have to be using a Creative Commons license. And these are all publishers that are using that supply side funded model. Either they're charging article processing charges or they're not, but in no case are they charging the readers subscription fees, and in all cases the content is available under a CC license. Other quick adopters, Wikipedia is under the buy share alike, meaning you have to give credit back to Wikipedia, and if you adapt any of the materials to create a new copyrighted work, you have to license that adaptation under the same license. So this is Wikipedia sort of trying to force the commons to grow. If you go on Flickr and put Flickr/Creative Commons, you'll find about 200 million photos under the full array of Creative Commons licenses. There's 40 million under the most open license there. That means if you want to go make a calendar and publish it and make money off it, that's fine, as long as you give the photographer credit. YouTube also allows you to put content up under the Creative Commons Attribution license. There are about 4 million videos on YouTube under that license. And even people like Trent Reznor, otherwise known as 9 Inch Nails, released his album Ghosts 1 through 4. It's an instrumental track. It was actually the leading seller on Amazon the week it was released, and that's under a Creative Commons license as well. I could give you lots and lots of other examples, but in every creative domain we've seen that the Creative Commons option speaks better to what the creators or the publishers want from what they're doing. And so obviously overall market share compared to all the creative works is pretty small, but it's not insignificant, and it does suggest that one size does not fit all, and this sharing ethos that is embedded in the license actually is desirable by a variety of folks. And that's the end of our Creative Commons module. Any questions?
When you're using Creative Commons, is it enough to put it on your front page of your website, or do you have to put the CC and the logo on every single blog post and every single page in order for it to be utilized?
Right, so you can do it either way. Within Creative Commons, we have a variety of challenges that we have not yet met, and one of them is to figure out technologically how you best associate the license with the digital object. Ideally, we want to be able to embed it in the metadata associated with the digital object and make it incredibly easy for you to just push a button and do that. We're not there yet, but as a copyright matter, as long as you tell people what you're licensing, whether it's, if you, on the front page you say, all the content that I created on this blog is under a CC license, that's legally effective because it's very easy to give this permission. And that's what the CC license is there to do.
So under the CC license, do you have to register it somewhere, or do you just state it and then it's so?
Right, you just state it and it is so. We would like to see the ability for people to register it so that, one of our challenges that's somewhat not within our control is search. How can you reliably search the web for CC-only content? And it's very difficult to do that right now. If we had a registry, that would be an easier way to do that. We don't have that yet. But legally, there's no requirement to do that. The license is, you can give permission as simply as, I ask you, hey, can I use your song on my next album? And you say, sure. You just gave me a license. That's how easy it is.
Hi, I have a question about folks at universities or institutions who want to develop materials under Creative Commons, kind of the tension between if the university wants to own the material versus if you as an instructor want to develop Creative Commons. What's the trend you're seeing at major universities?
Right, so we'll talk about that in a minute. There's an open question actually about who owns the copyright in faculty-produced works. But the license has to be granted by whoever owns that copyright. And I think it depends on what we're talking about. If it's scholarship, universities have a pretty hands-off approach to that. When it's teaching materials, then we see, especially if it's distance learning materials that were invested in by the university, then they want to have a say over the reuse of that. And so it's a spectrum of cases I've seen. In the back?
I put Creative Commons licenses on some of my stuff, and then I change it. I change what ones I want part of the license, but what if someone used it when I had some prior iteration?
Right, well you can't take it back. So if I took it under the license at the time, then I still have that license. But once you've changed it, everyone who comes to it later is subject to the later license. So, it is important to think about what you're doing in terms of, I want to share this and are these really the right terms? So you can change your mind, but you can't take it back. That's the short answer.
Briefly, what's the business model for Creative Commons?
As an institution, we've been foundation funded up until now, and there is a question about what's the sort of financial sustainability model, and that depends on what Creative Commons' job is, other than producing licenses. Is it to also sort of support the commons in other ways or not? And we will see going forward. We're convinced that having the resources to keep the licenses alive and online will not be a problem. But whether we can staff up a lot of the sort of hands-on educational and business development type conversations is an open question. All right, end of Creative Commons module. So we know about copyright, right? Rights of control that are automatic, that are granted to authors in their expression of facts and ideas. We know that Creative Commons is one way to shift the terms of use away from automatic exclusivity to automatic permission subject to some conditions. And now let's take those general principles and think about how and to what extent they apply in the context of scholarly publishing and educational publishing. So first, open. What does this word open mean? Generally, it means there are two things we're worried about. It's what are the terms of access and what are the terms of use? And there are disagreements about what it takes to count as open in both the scholarly publishing and the educational publishing space. I mean, is a Hollywood film an open resource? Anyone can go to it, as long as you pay $10 or whatever. It's free, right? It's not VIP, it's not invitation only. Does that make it an open resource? But you could argue that it is, but at least in these two domains, that would not count that, right? That paying for access is not what we mean by open. So the minimum condition that everyone seems to agree on in both educational resources and scholarly publishing is open means it's free to read. It's free to access on the internet. Where there's more disagreement is what rights of reuse do I have? Is it only whatever fair use might give me or whatever the limitations or exceptions? Or you know, can I reuse it? And if so, is it completely free for reuse, or are there conditions such as attribution, non-commercial, or share alike that are attached? And we see a variety of responses in both the open access and the open educational resources movements to this second question. So this is a sort of active topic of conversation. All right, let's talk about open access. So we know that the traditional publishing practices mean that authors sign away their copyrights. So this is, you know, I just went to see one of Elsevier's most popular engineering articles. It's on Science Direct. I'm sitting in my hotel room without an account, and I am offered the choice to pay $31.50 to have access to this article, right? So let me just translate. What the current environment is author who is not paid to produce the material, reviewers who are not paid to review the quality of the material, are engaged in a production process that leads to valuable information. All of the value is associated with the copyright that's transferred to the publisher. The publisher then exerts the control that the copyright gives them to demand $31.50 to the access to that content. And again, that's because that was a fair deal in the world of print. And the question is, does it remain a fair deal in the era of the digital network? And open access is suggesting no. That in fact, where the author's incentives are different from the publisher's, which they are in this case, the author wants maximum impact, the publisher wants maximum income, then we've got a division, and open access says we've got to do something about that. So the open access movement claims that we ought to be able to at least read all of this material online, either after some delay or right away, but in either case, sometime less than the life plus 70 term of copyright, right? Some period much less than those 100 years. This stuff, all the scientific record belongs on the internet. And there ought to be some level of reuse, but it ranges anywhere from free to read to full uses of free to reuse. The argument for open access is that there are at least 5 audiences that are served if the material is freely available on the internet. So they're what I call the serendipitous readers. This is not grammatically correct, but I am talking about the researcher who's in an institution that has paid access, but they're in a place or they're just using Google, and if it's open access, they're going to stumble upon the article and it might have an impact, but they would not have gone to do the proprietary database search and would not have found it. So because of its being open access, that researcher finds the article. Without it being open access, that impact would have been lost. There are lots of under-resourced readers all out there. My daughter was a high school student in a public high school. Her chemistry professor wanted them to learn how to do a research paper, said, go out and find some scientific articles, and they said, where are we going to do that? I said, well, a lot of your parents work for hospitals and universities. They have access. High school students are under-resourced readers, but community college students, there are lots of people in institutions that cannot afford access to the scientific and scholarly literature, and they are part of the target audience. People who are in disciplines where it would not make sense for them to subscribe, but as these disciplinary boundaries break down, research being done in some other discipline is actually relevant to them, and if they had access, they would see the relevance and the impact would be felt. International readers, obviously, some things may be targeted in an area that has geographic appeal, but again, it has this bleed over appeal. And finally, what are the machine readers? I think this is the most important audience. I'm talking about text mining. I'm talking about the ability to do computational analysis to help us understand the information that we've got. We've got too much information. Our human attention is the limited resource. We need to manage that resource better. We need computers to help us do it better. The computers need access to the full text in order for us to be able to develop the algorithms that will help us do it better. And you can only do that in an open access environment. I'm sorry, Crossref does not do it, all right? Distributed search across the databases using Crossref is not the same as the ability to machine all of that text in an open access environment. And this is one of the big potential upsides that open access offers. The UK government just announced that it wants to change its copyright law to make an explicit exception for text and data mining because of this point. They see it as part of their innovation policy, their economic policy. So it has not proven out yet, but these are early days. And to me, this is one of the more compelling reasons why we need open access. Okay, and it's good for the authors. The author that's looking for the impact will see an increase in the impact based on the data we have so far. We're actually seeing an increase, so again, the majority of the literature is published in subscription-based journals. The author pays the article processing charge. Finance model still accounts for about 3% of the literature, but it's the fastest growing segment of the literature. And so if you care about trend lines and momentum, it suggests that we're moving in a direction of shifting the financing model so that we'll have access upon publication. But we're a long way from that right now. In addition, the traditional relationship with respect to copyright that is just between the author and the publisher is changing as other parties to the value chain are asserting their ability to participate in the terms of trade. So even though the copyright is personal to the author, that author was able to create the work because the research was funded, and they're doing it in an institutional setting where they got institutional support. So both the research institutions and the research funders are saying, wait a minute, you don't just get to sign that copyright transfer agreement without thinking about its broader impact, the access denied impact. We're not signing on to that. And I just glossed over the point, right? The whole system is built on this interesting fault line. We don't actually know who owns the copyright in faculty scholarship. It's for complicated reasons, but the law changed in 1976, and Congress appeared to say any work created by an employee within the scope of employment is owned by the employer. There was a pre-existing teacher exception, and Congress said, well, we're just putting in the statute what the courts had already said. So the fault line is, did Congress invisibly import that teacher exception into the modern law, or did they wipe it out? If you just read the law on its face, they wiped it out, but at least a couple of courts have said we have to read the law in its context. Congress didn't mean to do that, so the teacher exception survived. So we don't have a definitive ruling and are not likely to get one anytime soon. So everyone acts as if the researcher is the author, but there is a real possibility that some court will eventually say, actually the university owns the copyright in all of this. And a number of universities already say that is the law. So Rice University makes that claim. And then they say, but we give back to the researcher certain rights to use their own scholarship. Okay, so we know that the authors need to be published, and asking authors to be the sole individuals to make the change is hard. This is the recycling debate. Should they have to drive the newspapers in cans to the recycling center every Saturday, or can they get a little institutional support to create open access? So funders are starting to say we need a return on investment. And so we're seeing a change in the terms and conditions of funding agreements so that authors are being told, if you accept this money, and you use the money to create research that will then lead to a copyrighted article, you agree not to sign away all the rights in that article as you might have before. You agree that you will provide for some form of public access on the internet so that the impact of this research will be larger, right? And we've seen the universities, Harvard, MIT, and a number of other universities are adopting policies that say, we the faculty on our own, even if the funder didn't tell us, we're going to give a copy of our article to the institutional repository because we want our research to have maximum impact. We don't want there to be access barriers to our research, and it's part of our fundamental values as educators to do this. Right, how do you make it? So basically there are two different ways. You either, you can sustain the subscription model by delaying the access such that librarians still find it to be the only reasonable to subscribe, right? And we see a lot of sort of dramatic rhetoric about these open access policies, but they're all based on predicting librarian behavior. Right, and instead of talking to librarians about whether librarians are going to cancel subscriptions, everybody else wants to say what librarians will do. So it's important for the library community to step up and sort of explain what that tipping point is, so that it can be clear that the subscription model is sustainable if that's desirable, with a public access component. It's just got to be delayed, but we don't know how long that delay is. Right. So the number of these policies has grown around the world at both the funding level and at the university level. The trend is clear. More and more institutions are getting involved in this information environment management and making the position that the scientific record belongs online. So that's what that trend line represents, is the institutional support for the idea that the scientific record belongs online. Right. Okay, many of you may have heard that, so engineers need to pay attention now, right? If you're not NIH funded, if you're NIH funded, then this is old news, right? Since 2008, if you took NIH funding, then you had to make sure that the NIH got a copy of your final manuscript after peer review, and that you deposited it in PubMed Central. Now, a lot of people signed those agreements, took those grants, and did not deposit. But the NIH has now said, we've given you enough time to adapt to this. If you haven't deposited, we're not going to give you any more money until you show us the links to all the prior articles that arose from the prior grants. So now the NIH-funded community is like, whoa, they're serious about this. Now, compliance was up to 75%, but there's still a quarter of the funded population that wasn't making their material publicly accessible. That behavior is likely to change as NIH has now reached for the stick. What the OSTP memorandum suggests is that everyone else who's getting federal funding is going to have to play by some version of the same rules, right? So the memorandum came out in February. It directs all of the other agencies that have $100 million or more in research funding to develop public access policies and plans. So by August, the agencies will be announcing what their plans are. So I'm talking National Science Foundation, EPA, Department of Transportation, Department of Defense, all of your friends in the funding space are under an obligation to have a plan in place by August about how they're going to create public access to the articles arising from their funding. People have, the public needs to be able to read, download, and analyze in digital form the final manuscripts produced by the authors. There's also a data access requirement. It's lighter, it's more, everybody's got to have a data management plan, not just the NSF. But the contents of that are still much more open. But I know you had an open data session, so to the librarians in the audience, I have a deck from another point, but remember that scene in The Graduate where Dustin Hoffman's out by the pool and he's getting advice about the future? He says, I don't know what to do with my life. He says, I have one word for you, son. It's plastic. Well, to the librarians in the audience, digital data is the next big thing. I have one word for you, it's data. Right? If librarians don't want to be involved in the data management, somebody else will be. It's a big opportunity, it's an important opportunity. So just an exclamation point on the session you had before. I heard that Purdue got some nice shout outs. Purdue's done a really nice job in putting librarians on the grants. And the data suggests that you get more money when the librarian's on the grant team because the funder feels like there's a greater chance that that data will be preserved, annotated, cataloged in the ways that we want it to be done. MIT also deserves a shout out. But if librarians don't want to play that function, someone else will. And so I'm off that soapbox, but it's a really big deal. And it's part of this OSTP memo as well. Okay, back to publications though. So at a minimum, the agencies are going to have to figure out a way in which the researcher will be obliged to put a copy of the file somewhere and to give the rights under copyright to the repository to make the articles publicly accessible. And that's where the friction may arise, because if you've got IEEE forms or other publishing forms that are in conflict with this funding obligation, then it's going to be on the researcher's back and their institution's back to mitigate that. And if you made a contractual promise, and it will be the university that made the promise to the agency that there will be public access, then the university's got to figure out a way to make sure that that researcher doesn't sign away those rights. And we went through this with the NIH policy, and there was that friction. I will say that most of the publishers adapted their copyright forms to take account of the NIH policy. And I would anticipate that a lot of the publishers will do the same thing. But particularly the society publishers may not see this coming yet. It will get worked out. Again, that it doesn't harm the society. If there's going to be a delay, the plan anticipates that we're talking about delayed public access. So nobody's trying to kill the Scientific Society journal. But we can have the journal and have public access at the same time. We know this. And so that's what these plans are based on, is how do we find that sweet spot where we keep those two things coexisting. But there will be copyright mechanics that have to be managed in this process. All right, so the agencies are all sort of facing these kinds of questions, and the plans they announced in August will have their answers. I have had the opportunity to talk to a few of the people about what their options are. There's already a copyright license granted in every funding agreement. It's supposed to be there. So the agencies could just rely on their existing license. They may not. NIH got scared away from doing so because they were basically facing the possibility of a lawsuit over whether it was a federal purpose to put stuff up online. Department of Energy, Department of Defense are relying on that license. This is now getting into the copyright weeds, but just be aware that the agencies have some internal struggling to do about this question. What NIH did is it created a separate license for the investigators in the room. The challenge here is that NIH says after you sign the publication agreement, you may have to make sure that you held on to enough copyright to give the agency permission to do this public access. That's a harder thing. It was easier to have given the rights automatically and then just have to tell the publisher, hey, I can't give you everything because I already signed a grant agreement. As opposed to, now my funder says I've got to fight with you about copyright. That's not a very fair position, but that is the position NIH took. I don't know whether the other agencies, which way they'll go. They have the option to just put it in the grant agreement so that the license is automatically granted to the agency, in which case the investigator just has to inform the publisher, this is the state of the world, I can't change it. Or they could say, we'll wait for you to enter into the publication agreement, but demand that you hold on to rights. So those are the two models. We'll see. I'm going to blow through these slides, but they're in the leave behind. But the mechanics are basically, under that first model, you're allowed to grant a license in advance of creating the work. So that means the moment the work comes into existence, the agency gets a copyright license like that. And it's my own anticipation that a lot of the agencies are going to find that to be attractive. So everybody who's in the sort of grants world expect new terms and conditions that will say, you hereby give a public access license in exchange for taking this funding. And then it will be a matter of helping the publishers adapt to that changed environment. Where is it going to live? Well, the policy says we're open to that. It's got to be in some stable repository where we know we're going to have public access, whether it's a centralized repository like PubMed Central or distributed repositories. We're agnostic about that. The agencies have to work that out. My own anticipation is that we'll see diversity. Some agencies seem to like the PubMed model, and I expect we'll see some centralized government-run, and others will be distributed. So PubMed Central is the centralized version. The publishers have put forward a proposal called Chorus, in which they would largely manage a distributed set of repositories where they would basically open windows on their servers to content after the embargo period ends, and they would get all the traffic data and the usage data, and they would create a piece of metadata called FundRef, where that metadata would identify the source of the funding, so you could search their website for all of the, NSF or DOT funded research. There are some issues. They have not talked about text mining. We'll deal with that later. If you read the OSTP memo to say the public has the right to analyze, if analyze means computationally analyze, then a proposal that does not permit text mining would actually be not in compliance with the directive. I think another risk the agency takes if they outsource all of the compliance to the publishers is when the General Accountability Office comes and audits compliance with the directive. How comfortable will the agencies be that, well, I got to ask the publishers if we're in compliance? Right? That's one of the risks of that model. As you probably know, the ARL libraries, along with other groups, have stepped up with a similar model. Let's tie together all the institutional repositories and we will provide access. My own advice has been, why do we have to choose? As long as the license the agency takes is sufficiently broad, it can permit mirroring. Why don't we let the publishers have a copy and the institutional repository, and if the agency wants, we're talking about public access here, right? And more points of presence increases impact. So we will see how this all shakes out. But this institutional change is happening. One other change to be aware of is, what is the role of publication, of peer review? So nobody's saying we need to get rid of peer review. But peer review answers three questions. Right? Was this published before? If it wasn't published before, is this valid research based on the validity measures we use in our discipline? And if it's valid, how important is it? Right? Now that third question was an important question to answer in the world of print, where you're going to invest scarce resources in creating these expensive printed objects, and it's only worth it to do that if there's some quality to the information you're encoding. In the world of bits, is it as necessary to answer the quality question prior to publication? Or could we have pre-publication peer review be limited to the validity question, and have post-publication peer review be the means of shaking out separating the wheat from the chaff? So that at least is the model that the Public Library of Science PLOS One uses. It's the fastest growing science journal in the world, and it's because it only answers the first two questions, and it leaves it to you, the readers, to decide how important this result is. And in defining how important it is, the other development are so-called article level metrics. Impact factor is a noisy measure. Right? It tells you about the impact of the journal. It does not tell you about the impact of this article. And again, we can use the technologies to break this down. How important is this article? And how should we measure importance? Is it only based on citation data? What happens if the Twitterverse is all aflutter about your results? Well, that doesn't necessarily mean that it's high impact. It could be, what a crazy article, this is nonsense, right? So we don't necessarily want to tie impact to noise. But on the other hand, if there's a lot of activity on Twitter and Facebook about a particular article, should we ignore that data entirely? Or should we try to synthesize that with citation data and other kinds of measures of impact and be more precise in our understanding of when research hits the sweet spot and when it doesn't? All right, that is the end of our open access module. Questions?
Hi, I'm Sue Kemnitzer from National Science Foundation.
Can we get the mic up here?
Hi, I'm Sue Kemnitzer from National Science Foundation, and I'm involved in the policy that NSF is developing and was so aptly described by our speaker. We really want to have your input to this as it develops, and in fact, as he pointed to, we're probably going to come up with quite an open, federated approach to allow many different places for the open access to occur, and obviously we very much need your to be in partnership with you. So this is just an invitation. I'm from the engineering directorate of NSF. Amy Friedlander, who's in our science behavioral directorate, is our lead expert. So please be in touch with us if you have concerns, questions, et cetera, et cetera. Thank you.
Other questions?
Hi, so you talked a little bit about the institutional and government organized databases and things like that. I was kind of curious where you saw the role of the more publicly organized data databases, such as like Figshare and Data Dryad and things like that in this whole process.
Yeah, well, I don't think we know the answer. I think, so Dryad is a data repository, but they've recently announced that they're going to start charging for deposit because their financial sustainability model is a challenge. So I think Figshare is an interesting site. It would be a nice acquisition target, unfortunately, right? It's a sort of Mendeley attractive target. So I think they're great ideas. I think there's a lot of entrepreneurialism that should be encouraged. But ultimately, you want the fundamental goals of the open movements to be achieved. And so sometimes when there's commercial interests at odds with that, then there's a tension. So it's early days. I think we had one question up here, and then I'm going to do OER quickly because I ran over a little bit. But
at least from my perspective, if this is going to be a continuing challenge, as long as we have that conflict within the university on one hand, wanting to have open access and dissemination of the information, but on the other hand, fiercely clinging to the traditional tenure and promotion criteria of getting those high impact factors so they can put that in their tenure portfolio. And how do we go about resolving this conflict?
Well, that is one of the big hopes of article level metrics, really, is that article level metrics will show themselves to be more reliable measures, and then therefore only a responsible P&T committee would have to look at that. But it's early days, right? I think the researchers dealing with the ALMs, the article level metrics, are being very careful about making sure they want a science-based, evidence-based approach to impact. So so it's too early to figure out what the right levels are, but we need to develop those, because you're right. We're relying on really noisy data to make these decisions. Okay, quickly, open educational resources. Because this is really early days here, I've mostly here's an FYI. I don't have a particular ask. But similar to open access, open educational resources is motivated by a broader motivation. At least some layers of the community want to make education more open, so maybe even break down the institutional model for education. So there's the sort of radical wing, and I use radical in the sense of it's a radical vision. It's not crazy, it's just radical, where we could deinstitutionalize or reinstitutionalize education in a different way. Others are just have more modest goals and say, well, at least the educational resources that are used within formal education ought to be freely available for those either in under-resourced formal institutions or self-learners, autodidacts, who just want access to these educational resources for their own enrichment and education. And again, we have a debate within that community about the reuse rights. There's a more general sense that some form of Creative Commons licensing is desirable, and so that conversation is more within the CC suite. Should it only be the attribution license, or should you add on the non-commercial or the share-alike conditions as well? And you see a variety of answers to that in different open education projects. So there are sort of I look at this as kind of three types of OERs that we've seen. And from the copyright lawyer's perspective, it's looking at the author's perspective on this. So the course materials and the supplementary materials that are created by educators in the normal course of doing what they do are the low-hanging fruit. They've already been created as part of the job. They weren't created with the expectation of any additional revenues or profits. And so as long as they're worth sharing, they ought to be shared. And if they're going to be shared, share them under an open license. And so that's why the sort of open courseware movement was kind of the early leader. Textbooks were always going to be difficult because the author's incentives are different, right? The author expects to be paid when they produce a textbook. And so their interests are more generally aligned with publishers. I actually am quite surprised at the speed with which the open textbook movement is taking place. And part of it is that the institutions are stepping up and willing to pay the author, but just pay them once. So the terms of trade are, we will put out a grant, you create a textbook, we will pay you, but it will be under an open license. So don't expect an ongoing royalty stream. You'll get paid for your effort, a fair price once, but then after that it's an open resource and we can use it and not have to pay and pay and pay again. And not have the 6th edition look a lot like the 5th edition, except we switch chapters 3 and 4. And then the most recent development are the massive open online courses. I put open in quotes because depending on your definition of open, it's not as open as the other educational resources. Right. So the course materials, you can look on OER Commons. There are a lot of places where you can find open course materials. Again, search is not as reliable as it should be. There is not a one-stop shop like that Flickr page where I showed you. If you wanted to see all the OERs based on which Creative Commons license they're under, there is not a good single place. OER Commons tries to be this, but it doesn't have everything that it ought to. In addition, in terms of public support, so the Department of Labor and the Department of Education under the Trade Adjustment Act have put a total of $2 billion into creating community college level courses to help the workforce retrain in different areas. As a term and condition of those grants, all of the course materials that are created have to be under a Creative Commons attribution license to make all of that as public resources reusable to the maximum extent possible. At the state level, we're seeing an increasing number of proposals in California and the state of Washington, and possibly a new bill coming forward in Congress that would take this principle and make it more general. In terms of textbooks, we've actually had a mix of there are some altruistic authors who are creating open in textbooks without the expectation of payment, because their educational mission, the educational fire burns so bright in them that, and it's funny, in the STEM subjects in particular, I find this to be particularly true. The innumeracy of the general public is of such a passionate concern that you see, like the mathematicians, are creating open textbooks because it is more important to them that people know math than that you get paid a little something for it. But I don't think we can build an entire system based on that altruism. And so the system needs to account for the traditional expectation of payment for textbook authors. And so we're seeing this. So I just flow through. Here are a number of sites. The slides will all be available where you can find open textbooks in the engineering disciplines. So these are just search results. Now, you often hear, okay, fine, it's open, but it's low quality. Any author who's willing to do this stuff for free must not be that good. And I would say I'm not in a position to judge the quality of these open engineering books. From my experience, I think there's a range of quality with these open materials, but there are definitely people who are aiming high. Flat World Knowledge was a company that entered the market to say, we can prove that you can make a profit and produce open textbooks. And they were doing that for a while until they raised $19 million in venture funding. And then the venture capitalists said, we don't think we it's not that we're not making money, we're just not making money fast enough. So we're going to close the resources. So they were the early leader and they left the market. They've now left the market open to OpenStax College, back to our friends at Rice and the engineering visionaries. Rice University is now the host to OpenStax College. This is an open textbook publisher. They're the leading open textbook publisher. They've recruited a very high quality editorial board to answer that quality concern, and they're going slowly but accelerating in the pace of what they're creating. So right now, the books they have are physics, sociology, biology, and concepts in biology and anatomy. Coming soon, they've got statistics, chemistry are on the rise. These are all print resources. You can download them free as PDFs, or you can pay for them in print. The print copies are much, much cheaper, extraordinarily cheaper than than what you normally pay, the $200, $250 that you normally pay. And these are really high quality books, and so the hope is that the model can be proven. These authors have all been paid, they were vetted, and so this is a real possibility for a sea change in educational publishing. The US Department of State agrees and is actually using open textbooks as a tool of diplomacy. So what the missions in the Middle East are taking those OpenStax books and authorizing the translations into Arabic with the idea that STEM education is a sort of not a particularly political way in which the US can promote development in the Middle East by using these open textbooks as a way of sort of promoting STEM education more generally. There's a real hunger for STEM education in the region, particularly engineering. They don't have engineering titles yet, but they've got about 25 titles sort of in the pipeline, and so I would imagine that we will see some engineering books emerge under that publisher in the near future, and maybe you might be the author of one of those books. We close with the MOOCs. Hard to know what to say about these. The model is we can either coexist with formal education or we can take it over. Not quite sure which one yet. There are a number of open education or open online courses. Among those, here's a place where you can find the existing lists. The circuits course at MITx is one of the most popular out there. Again, MIT taking a leadership role. You can also find some on Coursera. Interestingly, Udacity does not have any engineering. They've got basic courses. One other place you may not be aware of, that Michael Saylor made a lot of money off a company called MicroStrategy in the DC area. He's now funding open education out of his own foundation. And he's creating online courses, and they do have an engineering course. How open is it? That's a big question. edX, Coursera, Udacity, they're all in conversations about what the copyright licenses ought to be on their materials. As they keep adding new institutions, it gets harder and harder to come up with a single agreement. So I expect that we'll see a diversity of copyright terms associated with the course materials in these. And even if they're under an open license, can you really extract the materials such that you can reuse them? Will be a question, or will they use technological protection measures to sort of encode them into the course? So those are questions, not answers, but we're seeing a lot of movement. Obviously, we're seeing a lot of press. in this area, and the copyright piece is a piece of it, but the online access piece and how it gets financed are probably the dominant concerns there. And with that, I think I went slightly over time, I apologize, but I'm open for more questions if the organizers permit it, but otherwise, let me know.
I think we can stay a few more minutes for anybody who can stay on the line and talk to the professor.
Okay, so I'm available if you want to chat informally. Thank you very much.